you. Yes, Mr. Guy.
My lords, my lady, I appear on behalf of FM Conway with Miss Bodnar and Miss Keating. Mr. Reid and Mr. Kerry appear for the Rugby Football Union and Royal Sun Alliance, and Mr. Wheater appears for Clark Smith Partnership. My lord, I believe the first items on the agenda are the applications.
Well, I'm not quite so sure about that. Let's look at some of that. We have obviously read the papers, and we have, I think, a good understanding of what the issues are. We don't at the moment believe this should take 2 days, and so we'd like all council to bear that in mind, but we don't think at the moment that it justifies that sort of length of time, given the pre-reading, and I think when you strip it down, the relative simplicity, at least of some of the issues. As far as the applications are concerned, the position really is this: permission to appeal was granted on the basis that there were no disputes of fact. We should, wherever possible, stick to that. If one or other of you wants to refer to one of the documents in the unagreed bundles, well, we'll consider them de bene esse, but it would need to be explained why we're looking at them, given the judge's findings. So hopefully that will then mean that we can short circuit endless, dull skirmishing about stuff that ultimately probably won't matter. And we can instead concentrate on the points of law. So that's how we propose to deal with the applications. As I say, we'll consider any documents to bene esse, but the strong hint from the court is don't bother. As far as the timetable is concerned, as I say, please don't think that because it's down for 2 days, you've got 2 days. We think that it shouldn't take that long. I don't think there's anything else to add by way of introduction, save to say that this afternoon my lady's making a speech later in Gray's Inn, so we will need to rise at a convenient moment as soon after 4 as possible. All right?
I'm grateful.
Okay, so there we are. So let's get into the meat of it.
Thank you. My lords, my lady, we say that this is a very simple case that happens to sit at the intersection of several complicated areas of law. Despite the evident care that was taken over the judgment, we say the judge fell into several of the bear traps that exist in these areas of law and arrived at an answer that does not fit the findings of fact that he made, the terms of the policy, or the other contractual documents. And to be clear, my lord, the position is as it was when we sought permission and when your lordship granted permission. We do not seek to challenge any of the findings of fact. We rely on those findings. On the 17th of May, the Rugby Football Union entered into a policy of project insurance in its own right and as agent for Conway. The policy was to cover redevelopment works for Twickenham Stadium ahead of the Rugby World Cup. The RFU had decided to let those works as around 20 separate sub-projects instead of employing a main contractor with overall responsibility. It has always been common ground that the project policy was entered into by the Rugby Football Union as agent for Conway. The policy identifies the insured as including the contractor for each project and all other contractors. The policy does not differentiate in any material way between the cover provided to the RFU and the cover provided to Conway. Save that, it says that each insured is insured for their respective rights and interests. We say that means that each insured is covered in respect of their insurable interests as if they had taken out their own policy. The respondents say that those words mean that each insured is only insured to the extent of the RFU's underlying obligation to insure them. At the hearing below, the RFU and RSA described that point as being at the heart of the preliminary issue. However, it was not dealt with in the judgment and is the subject of 2 respondents' notices. In addition to identifying the contractor for each project and any other contractor as insured, the policy risk details specifically identify one of the sub-projects, being the A701 works. These are the works that Conway had commenced one day before the project was incepted. On our case, that means that looking at the policy alone, one can determine that the contractor for the A701 works is insured under the policy. One can't work out that the contractor is called Conway, but we say the fact that one has to look to the factual matrix in order to find out that the contractor for the A701 works is called Conway is immaterial.
There's some debate or there's some doubt as to the extent to which that element is in dispute. That's to say, the extent to which Conway was a co-insured. The judge didn't seem to find that they were, but it seems not to be disputed that they were a co-insured because they were capable of being identified.
So my understanding of the judgment, my lord, and I defer to your lordship's understanding, but my understanding of the judgment is that the judge did find that Conway were co-insured, just not to the same extent as the RFU.
Okay, so why does it matter then the point that you were making about, well, they were identifiable, because it doesn't say Conway, but it says the A701 contractor or subcontractor, and if you then did the research, that would be Conway. In fact, they were on site. So why does that point matter?
Well,
if you say the judge did find that they were co-insured.
So the reason that it matters, my lord, again in a nutshell, is that the respondents say that one is permitted to read down policy of insurance by reference to the intentions of the agent, being the RFU. That's the essence of their case as I understand it. That one is entitled to read down the extent of cover, not the fact that one is covered, but the extent of cover by reference to the intentions of the agent. Now, we say that that can be the case, but it is not the case when the principle is identifiable in the policy on ordinary objective principles of contractual interpretation. We say there is a difference between the situation where one can identify Conway as being insured by reference to the policy against the factual matrix, and the situation where one has to ask the agent whether they intended to insure Conway. And it's that latter.
So there's a difference between Conway being named and having to do the research to identify them.
There is a difference between the situation where Conway is described with sufficient certainty in the policy that one does not need to go to the agent and ask the agent what their intention was. They're the two situations that are distinguished in...
So where they're described with sufficient certainty as opposed to where they're not?
Yes, my lord. So it's
that's the difference.
Yes, in situation A, the principle is described in the policy with sufficient certainty that the agent cannot later say, I intended to insure someone else. That's situation A. Situation B...
I intended to insure somebody else.
Somebody else. That's situation A. Situation B is where the principle is not identified in the policy with sufficient certainty. It's identified as, say, for example, the contractor. And it's necessary to work out which specific contractor the agent intends to insure. The agent can be heard to say, via the principle of undisclosed agency, he can be heard to say at a later date, I intended to insure this person, that person, the other person.
But that doesn't arise here.
Well, they say it does, my lord. That's the issue. They say
I'm not sure it is the issue, but anyway. Okay, so anyway, that's fine. You say the judge found they were co-insured, but you say there's a difference between whether they can be identified with sufficient certainty or not, and we'll come back to that when we look at it in context. Yeah, right.
Yes, my lord. And I think it's common ground that the RFU and CSP's case is that Conway was insured, but it was insured as an undisclosed principle. That's what they say. It was insured as an undisclosed principle. And because it was insured as an undisclosed principle, the extent of Conway's cover is defined by reference to the RFU's intentions as at the point the policy was incepted. That's how they say this works. So we say, my lord, that it's settled law that a contract need not identify a party by name as long as that party is described in a way that is sufficient to identify them. In this case, the RFU has been indemnified under the policy in the sum of 3.3 million for damage that was caused to the works of a third-party contractor after the completion of those works. The RFU and RSA say that that damage is the result of Conway or CSP's breach of contract, and they seek to recover that 3.3 million from either or both of them.
And that is cover the damage to the works. Is that right?
So, my lord, it is damage to the works of another contractor, not Conway's works.
Well, under the which is the relevant interest insured.
So this is
page 152 of the core bundle. This is damage to the cables.
Yes, my lord.
So is that permanent works?
So, my lord, the cables were not being installed by Conway at all.
I know that. Could you just focus on my question? I'm just trying to see what interest it is that was insured under this policy that led to the payment out of £3 million.
So
I'm looking at page 152.
152.
Is it there?
So it was property insured under Section 1, my lord.
Because the cables were what? Permanent works?
So the cables, as at the time the damage occurred, were permanent works, as at the time the damage occurred.
Right. So that explains the payout of the 3 million.
Yes, my lord. But to be clear, that they were not Conway's.
No, Conway were putting in the ductwork that's allegedly defective and let the water in, which damaged the cables.
Precisely, my lord. Precisely.
I have said we've read the papers.
Thank you.
Yeah.
So the appeal is concerned only with what was paid out under the policy, those losses that were insured. There is another part of the claim, an additional million or so of uninsured losses. Conway does not say that it has a co-insurance defence in respect of those losses. Mr. Justice Eyre found, in summary, that the extent of Conway's cover under the project policy was coextensive with the Rugby Football Union's obligation to insure it. So, on the judge's analysis, the obligation to insure was to be found under either or both of the contractual documents, under either the letter of intent or the subsequent JCT contract, and the cover to which Conway was entitled was coextensive with the RFU's obligation to insure under those documents. Now,
Which is a conventional approach.
well, yes, my lord. So that's right. In many cases, that will be the extent of the cover, the obligation to insure.
Yeah.
We say that this is an unusual case in that there were communications as between the RFU and Conway prior to the inception of the policy, where the RFU's project manager and contract administrator said to Conway, "We intend to procure insurance for you that would give you more extensive cover, including cover in respect of the works of a third-party contractor." And Conway's director of engineering said, "We're happy for you to procure that cover, and we're not going to charge you anything for insurance." We say that that's an unusual situation, but properly analysed, that exchange is the giving of authority by Conway to the RFU. And so on our first case that Conway is identified under the policy as a principal, that means Conway benefits to the full extent of the policy, that its interest is not circumscribed by the underlying contractual obligation. Or alternatively, we say, if Conway is not considered identified in the policy and participates through the undisclosed principal doctrine, then that communication was a manifestation of intention by someone authorised to manifest that intention, that the project manager of the tender, the contract administrator identified in the letter of intent, and the manifestation of intention to procure wider cover, plus the authority given to procure wider cover, taken together mean that Conway is insured under the policy in respect of the relevant damage.
Irrespective of the contract.
Irrespective of the contract. The timeline is this, my lord. And again, I'll try. We will look at the contractual documents, but there is a letter of intent.
Yeah. There's a letter of intent. There's the policy. There's the JCT contract.
Exactly, my lord. The letter of intent, as we'll see when we go to it, does not identify any obligation on the RFU to insure Conway. There's nothing in there that says the RFU must or will procure cover for Conway to a certain extent. So the other side's case and the judge's analysis doesn't work on the facts of this case. The judge found, the other side accept, that Conway was co-insured as from the date the policy was taken out, as from the 17th of July 2012. So the analysis that the extent of their insurance is circumscribed by an underlying obligation in the letter of intent can't be right on any analysis, because there is no underlying obligation in the letter of intent to procure insurance. The requisite authority and intention to establish that agency relationship must come from some source other than the letter of intent. And we say that on the judge's own findings, and presently we will go to those findings, the judge found what the source of the requisite authority and the requisite intention was. The requisite intention is manifested when the person managing the tender for the RFU, the person that the letter of intent identifies as being authorised to issue instructions, says to Conway, we intend to procure this wide cover and you do not need to take out your own insurance. And Conway's Director of Engineering responds saying, okay, please do take out that insurance for us and we will not charge you anything for insurance through the tender. When that exchange occurs prior to the inception of the policy, that is the manifestation of intention, the manifestation of authority, sufficient to give Conway cover under the policy.
What would have happened if that, what on your case wouldn't have happened if that exchange had not occurred? What steps would your clients then have taken?
So if that exchange had not occurred, Conway would then have obtained their own insurance and charged the RFU for it. That's what would have happened. And the judge found, and we will look at the findings of fact because they are important. The judge found that exchange occurred, and he found that Conway did not charge for insurance, and he found that Conway did not take out their own insurance. And we say, my lord, prior to the inception of the policy, that's the only legal analysis that fits with the facts. The manifestation of authority, the manifestation of intention. The letter of intent theory does not fit with the facts because the letter of intent does not require the RFU to take out any insurance at all. And as we shall see, the insurance situation was not settled when the letter of intent was taken out. 3 weeks after the letter of intent is taken out, the RFU tells Conway that it is not required to provide JCT 6.5.1 insurance. At the initial tender stage, when the tender documents were sent out, the tender documents said Conway may be required to provide a range of insurance. One of the insurances identified was JCT 6.5.1.
That's employer's liability, is it?
Non-negligence.
Yeah.
Non-negligence, my lord.
So not relevant to this.
So relevant only in that, as at the time the letter of intent is sent out, the insurance arrangements are not.
Well, we know that from the policy, because the policy says 651 may be required. So we know that. We don't need that point of fact. We can get that from the policy at page 162, clause 6.5.1 may be required.
And my lord, we also know that the authorisation within the RFU to take out the policy only occurred on the 17th of July. That's one of the judge's findings of fact, that
Yeah.
within the RFU...
After the letter of intent. So it comes back to the letter of intent. What's the relevance of the letter of intent?
So
that's one of the more important issues.
It is, my lord. It is, my lord. And on our case, the letter of intent contains no requirement
Well, you made that
to ensure, and it identifies Mr. Higgs as having authority to issue instructions about these works.
Well, he was the project manager.
He was the project manager and the contract administrator.
Yes.
Yes.
He was not the RFU.
No, but he was the contract.
He was the project manager. He was a third party under any construction contract. The project manager is acting for the employer. He's appointed by the employer.
Yes.
He's not the employer.
No, my lord. But if we look at the letter of intent,
Yeah.
this might be a opportune moment to do that.
Page 225. Yeah.
225, my lord. Thank you. And if your lordship looks at paragraph 6, please.
Paragraph 6. Yeah.
We have appointed RLF 3PM LLP to act as the contract administrator for the purposes of the works.
Yeah.
You will must liaise with the contract administrator, comply with instructions issued by him in relation to the works as if the contract had been entered into. So
That's an entirely standard clause in a letter of intent from an employer to a contractor.
it is,
Saying you must do effectively what the contract administrator tells you to do.
exactly, my lord. But the contract administrator...
Unbedeviled by questions of authority and agency and principle and all of that. It's just a standard building contract provision.
So what we say about this clause is that Mr. Higgs, as your lordship knows, was the partner in RLF 3PM.
Yeah.
So what this clause is doing is identifying to Conway that Mr. Higgs has authority to issue instructions on behalf of the RFU.
Yeah.
And his role as project manager for the tender, we say, carries with it ostensible authority to inform Conway about things relevant to the tender. If you're having a tender negotiation, somebody in that tender negotiation has to have authority on behalf of the RFU to say to the other side, this type of insurance is required, that type of insurance is required. And it's the project manager managing the tender, we say, who has that apparent authority by virtue of the fact that the Rugby Football Union have designated him the project manager managing the tender. When
No, this is managing the contract.
so two roles, my lord. Yes. So he has.
This has nothing to do with the tender. This is the plain straightforward. This is the project manager. He'll be issuing the instructions.
So he has. Mr. Higgs has two hats, my lord. He has two hats. He and it's common ground that he was the project manager for the tender. RLF 3PM were the project managers for the tender. So he had authority as project manager for the tender, and as from the date this letter of intent was issued, the 19th of June 2012, as from that date, he also had ostensible authority as the contract administrator for these works.
I don't understand what that's got to do with this case, that he had ostensible authority as contract administrator for these works. So what?
So we say, my lord, that when Mr. Higgs says to Conway, the Rugby Football Union will be taking out insurance that covers you.
That's the tender. That's the first hat.
Yes.
I'm asking you, what's the relevance of the second hat to the issues in this appeal?
Well, my lord, because some of the relevant communications were after this letter of intent was issued.
Yes.
So all we say in relation to this is that this is furnishing him, in the terms of ostensible authority, this is furnishing him.
Most employers don't negotiate their contracts through a third party. So it's the first hat that we're interested in. Anyway, is there anything else you want to show us in the letter of intent since we've turned it up?
Well, look, as we're here, I'll deal with this now. And if your lordship looks at, please, at page 226.
Yeah.
And paragraph 10.
Yeah.
That's the only thing that this letter of intent says about insurance. And
well, not quite, because paragraph 3 refers to the JCT contract.
So
that it's 3 and then specifically 10.
And I will return to 3, my lord.
Yeah.
But the only thing that is specifically said about insurance is in paragraph 10.
Yeah.
And what is said about insurance in paragraph 10 is that Conway will have to provide evidence of the insurance that it is or will be required to provide. That clause says nothing about the RFU's obligation to provide insurance. And it also says nothing detailed. It doesn't say that Conway has to provide any specific insurance, because as at the time this letter of intent is issued, the insurance arrangements are still being negotiated. They're still not settled. The RFU doesn't know for sure whether it will be taking out project insurance. So it's possible, as at this point in time, that Conway will have to provide some insurance. It's possible at this point in time that Conway will not have to provide insurance.
Now, what does the last sentence of 10 mean?
The last sentence of 10. Yeah, we require evidence of. So we say, my lord, that only relates back to the extent that Conway is or will be required to provide such insurance.
Say that again.
We say that the previous sentence says that you don't read those two sentences disjunctively.
Okay.
The previous sentence says, you must provide us with certificates of verification of insurance confirming all insurances which you are or will be required to provide, and then it says in particular. But in particular is still read together with that you are or will be required to provide. So there is a separate question, what are you or will you be required to provide? And again, on the facts, my lord, there is an email exchange.
Well, before you get to that, my lord has taken you back to paragraph 3. There again we see reference in the middle of paragraph 10 to the proposed contract.
Yes.
Yes.
And I was going to return to that, and that too is important, my lady. The meaning of that is of course important. Perhaps I can address it now. What we say is that the law relating to letters of intent is the law as stated by Mr. Justice Edward Stewart in Volker Fitzpatrick and Twintech, which is that you imply into the letter of intent what is necessary to prevent the contractor being in breach of any subsequent contract that has retrospective effect. That's what you imply into a letter of intent. You do not imply everything in the coming contract back into the letter of intent. And the reason you don't imply everything that is in the coming contract back into the letter of intent is for the reason that Mr. Justice Edward Stewart gave in that case, which is that the very purpose of a letter of intent is to allow the parties to keep negotiating all of the other terms. And if you imply back everything that is going to be in the future contract into the letter of intent, you denude the letter of intent of purpose. There isn't anything more to negotiate. And if we look at the specific wording of paragraph 5, my lady, that confirms what we say, because it says, although the contract has not yet been entered into, all the terms and conditions of the contract will apply to any work carried out by you pursuant to the instructions contained in the letter. So what you imply back, we say, is whatever is necessary to stop the contractor being in breach of the contract that is ultimately entered with retrospective effect. You do not imply back the insurance provisions that relate to the employer, because the insurance provisions that relate to the employer aren't going to cause the contractor to be in breach. And that
you don't apply back option C.
You don't apply back.
I need to see authority that a letter of intent that says you will perform works under a JCT contract, and when that JCT contract is entered into as envisaged by the letter of intent, some provisions you do relate back to the start date, some you don't.
So
I'm bound to say that I find that surprising.
So my lord, the authority is Twintech. Sadly, it's not in the bundle because I didn't understand it to be controversial. But
as I said at the start, the letter of intent is key. So if the contract had been entered into on the 19th of June, much, if not all of your points would fall away. Your points rely heavily on the fact that the judge shouldn't have had regard to the contract because that was months down the line. Mr. Reed says, well, look at the letter of intent. You say, well, the letter of intent doesn't get him home, and those are the submissions you're outlining now. So what is or is not the effect of the letter of intent is clearly very important. So anyway, you say you don't apply back the insurance provisions. So option C and all the provisions in the JCT relating to that only took effect from the date that the subsequent contract was entered into, was not retrospective.
So my lord,
is that right?
Not exactly, my lord, because the policy is entered on the 17th of July, and what we say is,
forget about the policy. I'm just looking at the contract. This is a question of contract construction and letters of intent. Cleveland Bridge, all of that. So do you say that option C and the provisions in the JCT contract relating to option C in this case only took effect from when the contract was entered into, or do you say it did relate back to the 19th of June?
We say that the requirement to procure option C insurance only takes effect as at the point in time when the JCT contract proper is entered. The requirement on the RFU to procure that kind of insurance only takes effect when the contract is entered.
Is that consistent with paragraph 5 of the letter of intent?
We say it is, my lord, because the only, first of all, it's the terms and conditions of the contract will apply to work carried out by you pursuant to the instructions contained in this letter. And I guess I need, with your leave, I need to add Twintech to the bundle, but I did not understand this to be controversial.
Well, I think you probably should assume it may well be. I hope that's a fair reading of the position.
It's a fair reading of the position, my lord. We say the only terms that you apply back are the terms that are necessary to avoid the contractor being in breach of contract.
That isn't what 5 says. It says all the terms.
All the terms that the terms and conditions will apply to, all the terms and conditions of the contract will apply to any work carried out by you pursuant to the instructions contained in this letter. I say that is to be read on authority as meaning that it is the terms and conditions that Conway is required to comply with to avoid breach. And I say that the problem with reading it another way, my lord, is that if you literally apply back all of the terms and conditions in the future contract as at that point in time, then what is being negotiated after the letter of intent? You have a position where the insurance arrangements have not yet been settled. They're still in flux at that point in time. So if someone had asked either Conway or the RFU on the 19th of June, what are the insurance provisions that apply or will apply to this contract, the answer would have been, we don't yet know what will apply to this contract.
All right, well, is there anything else on the letter of intent?
No, my lord.
Right, okay. So where do we go now?
So the only other point to make on the letter of intent, it's not a point on the letter of intent specifically, it's a point on the law that applies to the letter of intent. We say that the judge's finding and the respondent's case that the extent of cover under the policy is coextensive with the extent of the obligation to insure under the letter of intent is not the law and never has been the law. And that even if we are wrong about the interpretation of the letter of intent, even if the letter of intent does contain an obligation to insure Conway in respect of something less than the relevant loss, even if that is the obligation in the letter of intent, we say that there is no legal principle that would stop the communication of authority and intention to procure a greater scope of insurance. And when we go to national oil well, we will see that the judge analysing the problem in National Oil Well is looking not just in, if I can discuss National Oil Well very briefly at this stage, it might be helpful to discuss the principles in there. In National Oil Well, there was a provisions to the contrary clause in the insurance policy itself. It said the relevant party, the other assured, are insured under the policy, save to the extent that there are provisions to the contrary in the underlying policy. Even with that kind of wording in the policy, Mr. Justice Coleman was prepared to countenance and search for the manifestation of authority and intention, not just after the making of the underlying contract, but he was prepared to search for it in the pre-contract negotiations. The exercise that he undertakes in that case, which we say is the right exercise, is to say, here is the cover that the contract provides for, here's the cover that the underlying contract provides for, then is there anything else that shows greater authority was conferred? Is there anything else that shows the agent manifested greater intention? And he's prepared to look for those things in pre-contract negotiations for the underlying contract. He's prepared to look for these things in communications after the conclusion of the underlying contract. And he's even prepared to look for those things in conduct. So he says in National Oil Well, were it the case that the usual course of business in this industry is that the agent would have had this authority, then I'd be prepared to find that he had it, notwithstanding the fact that the underlying obligation to insure is less than that, is less than the cover that the principal is contending for. So we say that there is no principle of law that says cover is coextensive with an underlying obligation to insure, and we say that was an error of law that was made by the judge.
Well, Mr. Justice Coleman, I think, said that the best source of the authority is the agreement, which you agree is the conventional approach. And he said there was a strong inference, I think he said strong inference, that the authority was coextensive with the obligation.
He did. But
in that case, as you say, he may have looked at other things, but that didn't dissuade him from either of those conclusions or the conclusion that the loss wasn't covered.
Well, my lord, we say it's vitally important to look at the facts of that case. And the facts in that case, and the contractual...
I'm very happy to do that rather than...
Yes, I'm not familiar with this case, Mr. Regard, so I would like to look at it. Rather than, I'm sure your summary is absolutely pinpoint accurate.
Let's go to it. Page 66, my lord, in the bundle of authorities.
The transcription team have asked the opus references just so that they can transfer that on.
So I do not know all the opus references, I'm afraid.
And I'm afraid we're all working from paper, so I certainly don't have a second load of references, I'm sorry.
G41.
Yeah.
So if I can start with some of the background to this case. If we look at page 70, at the bottom of column 1 and the top of column 2, we see that Davies was a shipbuilder instructed to construct a FPSO, and in November 1988 it enters into a subcontract with National Oil Well for the supply of a subsea module. If we go on to page 7, sorry, 72, I do have an electronic bundle reference, it's page 7 within the electronic bundle reference, but 72, we see here that in January 1989, so after the subcontract between the parties, Davies takes out a policy of insurance that contains the following definition of other assured. We see the definition at the top of the right-hand column. So any other company, firm, and so on. But importantly, if your lordships look at the paragraph below, it says expressly within the definition of other assured, unless specific contracts contain provisions to the contrary. And you can't read National Oil Well without understanding the significance of this provision, which does not exist in our policy of insurance.
Well, on one view, that might make it a relatively helpful case, but not very important.
Well,
it's slightly odd to be taking us to a first authority, and your first submission on it is that actually it's very fact specific, as indeed so many of these cases are. So my lord, it's all of these cases, exactly as your lordship said, all of these cases are very fact specific. Yeah.
But there are very important principles in this case that have carried through over the subsequent 30 years.
Yeah,
and have been approved.
I understand that.
But the important thing to understand here, if I may, is that the starting point is the definition of insured in the policy. It's the definition of insured in the policy that tells us, to some extent, what's important in the matrix, what's not important in the matrix, what we can consider, what we can't consider. And this definition of assured is telling you that you have to look at the underlying contract. It's saying that a party is not insured, or saying unless specific contracts contain provisions to the contrary, in which event insurance hereunder for such specific contracts only shall be limited accordingly.
Yeah.
That is a provision that does not exist in our policy. Yeah. So when Mr. Justice Coleman is saying later, as he does, that a strong inference is drawn from what's in the underlying contract, it's hardly surprising on the wording of this policy, because the wording of this policy instructs you to look at what is in the underlying contract.
Well, forget about the wording of the policy. Do you disagree with the principle that the most obvious source of authority is the agreement, whether or not these words are in or out?
No.
You don't disagree?
Don't disagree. No.
So it's a distinction without a difference.
Well,
anything else would be heretical, wouldn't it? That you don't have regard, at least in the first instance, to the agreement.
Of course.
I mean, that's sort of insurance contracts lesson 1. I don't think I made lesson 2. Lesson 1. I mean, that must be right. It's what people agree in writing.
Well, of course one has regard to that. Of course one does. But the simple proposition is this, my lord. If A and B contract on Monday, if they enter into an underlying contract on Monday that says A will procure insurance cover for B to this extent. That there is no principle of law that stops them on the Tuesday, that stops on the Tuesday authority and intention being communicated between them that gives rise to a greater level of cover. There is nothing that stops that. There is nothing that says the authority and intention that are communicated on the Tuesday are trumped by the contract that was entered into on the Monday. And that's the effect for which the respondents are contending, and that is what effectively what the judge finds. The judge finds this through the application of a set of principles that we say on proper analysis are irrelevant. There is no, as your lordships know, agency does not need to be a contractual relationship. If the principal authorises something and the agent agrees to do it, then that has legal effect. Does not need to be a contractual relationship. And there is no principle.
We'll get onto it, and I don't want to interrupt you now, but one of the things that I have been thinking about in reading this is, what if the agent doesn't do it?
What if the agent does not do...
What if the agent does not do that which he's authorised to do?
That's a very interesting question to which I do not immediately know the answer.
Well, it may be important because I appreciate there's an overlay of principle and agency here. I understand that. But we may, depending on what else the court finds, it's at least conceivable, isn't it, that we could be in a position where that becomes a relevant consideration.
So my gut reaction to that, and I'm not in a proper position. The honest reaction is that I'm not in a proper position.
Fine, then don't answer it. But
on that question at this moment,
don't answer it. Squirrel away the question. but and it may be irrelevant. I don't know. But it is a question that has occurred to me in the last few days.
It's to the extent that the court cares about what's interesting and what's not interesting, it's a very interesting question.
Well, I think you've got to be careful about using the word interesting, Mr. Garley. We have a packed court and it's being live streamed, so I'm sure it's very interesting to lots of people. I don't think you'd necessarily find that that was an adjective that applied across the piece.
I take that point, my lord. But importantly on this, we say that it is almost self-evidently the case that if what happens on the Tuesday amounts to a relationship of agency properly analysed, if that is the case, then it does not matter what happened on the Monday. It does not matter that the contract entered into on the Monday provides only for a limited scope of insurance. If the RFU said on Tuesday that it would procure a more extensive scope of insurance and Conway authorised that, and the policies entered into on the Wednesday, that is the scope of insurance. And the reason in this case that we have to look back to what happened on the Monday is because there is a clause in the policy itself that says you look back at the underlying contract. That's why we look back at what happened on the Monday. In our case, there is no such clause in the contract, in the policy. There is no clause in the policy that says the extent of cover is circumscribed by an underlying contractual obligation.
Okay, well, we have that point. What else about National Oil Well that you want to draw our attention to?
So, several things, I'm afraid. If we could go on, please, to page 77.
Yeah.
and look at the sidelined portions here. What Mr. Justice Coleman is dealing with in National Oil Well, the situation he's dealing with after this, his analysis after this, is related to the position where National Oil Well is not specifically identified as co-assured on the face of the policy. We see that in the red sidelined section. In
Page
view of the fact,
77.
page 77, my lord.
I'm afraid I don't have red. I have a short passage
I'm
in the
sorry.
second column at 593. So in this case, there would be no reason why, as a matter of law, the insurers might not become bound to NOW as co-assured on terms which differed from
Oh,
those.
is that the version? I'm so sorry. I'm so sorry. We'll see if we can do something about that if it's not.
The colour doesn't matter, but is the sidelining more extensive?
It should be.
Or
my
where does it
lord.
begin?
So
Hold up again.
it should run down the paragraph.
It goes on
Yes.
in view of the fact that.
Yes. It's the in view of the fact that we say is important.
Okay. Right. Oh, should we read it?
Yeah.
Where do you want to? How far do we go? Hold that page. To
Down,
whereas.
down to whereas, exactly,
Okay.
my lord. Down to whereas. My lord, what we say about this, what we say about the subsequent analysis, is that the subsequent analysis is concerned with the situation where the putative principle is not identified in the policy. And all of Mr. Justice Coleman's analysis that goes to reading down the extent of cover by reference to authority and intention arises only in a situation where the putative principle is not identified in the policy. We say that that's not the situation here. And I know your lordships have read Magellan Spirit. In Magellan Spirit, I won't go to it now, but Mr. Justice Leggett, as he then was, sets out the starting proposition. And the starting proposition is that one construes a principle's contractual obligations objectively by reference to the words of the policy. So,
For my part, I'd like to look at that. I haven't looked at that.
so perhaps we could
Briefly, could we look at that?
yes. So that is the order I would be planning to take this in, starting with Magellan Spirit. But my job is to help your lordships, not to take things in the pre-planned order.
No, I don't want to.
No.
derail you,
No. You.
But you mentioned Magellan.
Well, your lordship has taken me to the case that I intended to go to first.
Okay. I mean, the passage
180.
that you've highlighted now from National Oil Well leaves us with the words "in some doubt." So that's not helpful for my part. That wasn't how the doubt is resolved.
Well, we'll come back to it, but let's start. If we go on to page 188, please. That's Magellan Spirit. And here Mr. Justice Leggett is discussing the undisclosed principle doctrine and the fact that the undisclosed principle doctrine is an exception to normal rules of construction. If we start, please, at paragraph 15 rather than paragraph 16.
So you know there are no sidelines on these pages.
None at all, my lord.
No, there's none on mine. There's nothing on page 188.
I'm sorry, my lord.
What should be sidelined?
So what should be sidelined is the whole of
15, 16.
15, the whole of the next page, and down to the bottom of 19 on page 190. For some reason, it's correct on the electronic version that's coming up on the screen, but that's not much help to your lordship. So
It isn't.
I apologise.
Look, the simplest way through is just when we get to a page, you tell us what's been sidelined.
Thank you, my lady.
I mean, we'll have to read this in our own time rather than take time now, but can you summarise what the point is here?
Yes. The starting point is that in contracts entered into through agency, where the principal is identified, you do not look at the intention of the agent. That's the point. The idea that one looks at the intention of the agent in order to define the obligations of the third party offends against the principle of objective contractual interpretation. That's what Mr. Justice Leggett is saying here. That when you have an identified principle, in order to work out what the obligations and rights of that identified principle are, you look at the contract. Problem with using the term the contract is that it has multiple meanings here. So let me be more specific. The policy. If the principle is identified in the policy, you construe the extent of the principle's rights under the policy by reference to the terms of the policy. Looking at what the agent subjectively intended to do or what the agent communicated is an irrelevance. That's the point in a nutshell. So what Mr. Justice Leggett is setting out at paragraph 15 is the starting point, that construing contracts by reference to the intention of the agent. And it has to be remembered, my lord, that construing the policy by reference to the underlying contract is a species of construing the policy by reference to the intention of the agent. You have a policy that is between, let's say for these purposes, three parties: the insurer, the principal, and the agent. And you have an underlying contract that the insurer is not party to. So it's a violation of the objective principle that one construes the insurer's obligations under the policy by what two other parties, the agent and the principal, subjectively intend, or what they subjectively communicate as between each other.
That would lead to an extraordinary result, because if you have a policy, if there are two co-insured under the policy, you would then be saying, well, the contract between the co-insured, even if as between them they agree what is covered and what is not, you would say that was irrelevant. So you'd say it's a species of looking at what the agent intended.
So as between
wouldn't you? That would be right. That would be that would be the necessary consequence of that.
Well, that has to be disentangled, my lord. That can't be left as it is. As between the insurer and the principal, that would be irrelevant.
No, we're in principal and agent here.
So,
and in this case, you have an agreement between the principal and the agent. Take a hypothetical case, an agreement between the principal and agent in which the principal and the agent sort out, as between them, what they're going to be liable for and what they're not. You say that's irrelevant because that would be going to the agent's intention.
So that, my lord, is the whole point of the co-insurance defence, cooperative, and the Guard Marine case. That's.
But just stick to my point. That's right, isn't it? It must be the consequence. If you say looking at the underlying contract is a species of looking at what the agent intended, and that is illegitimate, then you are saying you don't look at the underlying contract, even if the underlying contract, as per Lord Justice Ricks in Tyco, is sorting out as between the co-insured where the extents of their liability are.
So can I put it like this?
Well, I'd like a yes or no.
I need to answer it precisely, my lord, because there's a lot that needs to be disentangled in that. If party A enters into a contract with parties B and C, where party A undertakes to confer rights on B and C. So the insurer undertakes to confer rights on party B and C. That's a contract, it's a freestanding contract, all three parties are identified. The fact that parties B and C decide between them that party A should not be conferring rights on party B does not affect the relationship between party A and party B. It can give rise to effects in the relationship between party B and party C, but it doesn't affect the rights between party A and party B. If I may put it this way, and forgive me for using individual. If I enter into a contract where I will pay Mr. Reed £100 and Mr. Kerry £100, the fact that Mr. Reed and Mr. Kerry between them agree that I should not pay Mr. Kerry £100 does not affect my obligation to pay Mr. Kerry £100.
Okay, so is there anything else in Magellan's spirit?
So the point, the 2 points that one gets from Magellan's spirit are, firstly, the starting point that can I qualify what I just said in one way. If the contract between A, B, and C refers to a contract between B and C, then obviously that qualifies.
Well, that's what Mr. Justice Leggett says at paragraph 17.
Exactly, my lord. Exactly. So the policy that we were looking at, before, the National Oil Well policy, does say something about the contract between B and C. It says in terms that I, insurer A, will only confer rights on party C to the extent that the contract between parties B and C require me to do that. That's what the policy says in National Oil Well. But if the policy does not say that, and parties B and C are identified on the face of the policy as insured, then what parties B and C agree between themselves does not circumscribe the insurance. I think I'll give your lordships a concrete example by reference to the policy here. If we go to the core bundle on page 150, please. That's the risk details and the definition of insured. One of the insured here is Barclays Bank. Barclays Bank is, on any view, specifically identified in this policy. It's common ground that this is a composite policy. On everybody's case, the words each for their respective rights and interests mean that this is a composite policy, which means that it takes effect as separate contracts of insurance between each insured and each the insurer and each insured. It takes effect as separate policies of insurance. Because Barclays Bank is identified in this policy, you construe Barclays Bank's rights under this policy by reading the terms of the policy. You do not construe it by reference to an agreement that Barclays Bank has reached with the Rugby Football Union. That's what Mr. Justice Leggett is referring to in Magellan as the principle of objective construction. That's why in National Oil Well, Mr. Justice Coulson makes it clear at the passage that was not redlined but should have been, that his whole analysis is in view of the fact that this party is not specifically identified. And sorry to jump around, but I just want to take you back to that. Page 77 in the authorities bundle, please. The bit that should be redlined, second column, begins in view of the fact that National Oil Well was not specifically identified as co-assured on the face of the policy. And then his entire analysis after that is about reading down rights that would otherwise exist on a straight reading of the policy by reference to intentions. But that reading down of rights by reference to intentions only happens if you are not specifically identified on the face of the policy. If you are specifically identified on the face of the policy, the Rugby Football Union doesn't get to say, I didn't intend to insure Barclays Bank to the full extent of the policy. The Rugby Football Union doesn't get to say, no, my underlying contract with Barclays Bank provided for a lesser scope of insurance than is manifested on the face of the policy. Therefore, they are only insured to that extent. It's a violation of the objective principle that you read, you interpret a contract by reference to what it says, not by reference to intentions manifested between some parties to the contract.
The logical extension of that is that if you've got two co-insured and they're both named, they're both covered for everything, full stop and done.
Absolutely.
And that submission was, if I've understood the transcripts, that your primary submission at the beginning of the case, but not at the end.
No, my lord.
And
no.
Well, I think yes, because, but well, let me ask you: is that your primary case?
My lord, our primary.
If you are named as co-insured in the policy,
yes,
nothing else matters.
No, it's not that nothing else matters. What matters is authority. That's what matters. So we've been talking about intention. But there are two ingredients.
So then nothing matters except
authority. So, if I may again,
just explain that. Whose authority?
Conway having given authority to procure that cover. So,
no, I'm talking theoretically. If you're named as a co-insured in the policy,
yeah,
then you say nothing matters, underlying contracts and so on don't matter. The only thing that matters is authority.
The authority of the authority that has been given by the putative principle. So the agent.
There might not have been any authority given.
Exactly. So
I don't understand the answer. Authority may have been given, but it may be one of those circumstances in which two co-insured have simply agreed a single policy with the insurer.
But they can't agree that with it. So if we have to disentangle various situations.
The disentangling does the tangling. That's why I'm trying to keep it simple.
But my lord,
your point is, if you're named as co-insurer, then you don't look at the underlying contract. That was the submission you were making. So I was saying, well, what do you look at? You say authority. So the authority given by the putative principle. So that's all that matters.
You can be named as insured by two routes, my lord. You can enter into a direct relationship with the insurer.
I'm sure you can, but however you get there.
But there are differences in
it was your submission. If you are named as a co-insured in the policy, then you don't look at the underlying contract.
You don't look at the you don't look at the underlying contract unless the policy directs you to.
Okay, and here you say it doesn't.
Here it doesn't.
So that's why I say in this case, the simple proposition would be, well, I'm a co-insured. There's nothing in the policy that differentiates me from the RFU.
But it's still necessary for Conway to demonstrate that it authorised the RFU to enter into it, because this is not a situation where Conway has approached the insurer directly. If Conway
I understand that.
So if Conway had approached the insurer directly, then this agency analysis it wouldn't apply, because on everybody's case, Conway participates through the agency of the RFU. They need to have authorised the RFU to act on their behalf. And the distinction between the situation where Conway is named insured and Conway is not named insured is that where it is named insured, the intention of the RFU, whether or not the RFU intended to insure it, is a complete irrelevance. You get intention from reading the terms of the policy. You can't read down the terms of the policy by reference to the subjective intention of the RFU. You can't read down the terms of the policy by reference to a contract between Conway and the RFU. But because the contract has been entered into through agency, Conway still needs to show that it authorised the RFU to do that. But if Conway can show that it authorised the RFU to enter into the policy and that it is named insured, you construe the policy objectively. You just read what it says as if Conway...
And you don't look at the underlying contract.
You don't look at the underlying contract to derive intention, my lord. The underlying contract may be a source of authority. It may be a source of authority, but you don't look at the underlying contract to derive intention. You don't need to worry about intention at all, because you construe the contract objectively, its words, against the factual.
Here, when you use the word contract, you mean the policy.
The policy, yes.
That's right. Yeah.
Does paragraph 19 of the judgment in Magellan Spirit us with this or not?
Let me return to it, my lord.
190.
I mean, it's so what's being set out in paragraph 19 is a refinement of what Mr. Justice Coleman said in.
Well, it looks as though Mr. Justice Leggett doesn't agree with it.
He doesn't agree with
refinement is a euphemism there.
So he doesn't
In
agree.
fact, it's not a euphemism. It's with respect. I think you may have just. I want to find another word. He disagrees.
Dubitanti.
So
Latin. See.
I'm afraid I don't have any.
There we are.
So what Mr. Justice Leggett is disagreeing with him.
Yeah, I need to obiter. I can use another Latin.
that one I know.
That one you know.
He is disagreeing with him, but he's disagreeing with him to a limited extent. What he's saying there is that subjective intention is irrelevant. It's communicated intention that is relevant.
Yes.
So if I and I'm sorry if this is repetitive, but this is. I referred at the beginning to bear traps and the complexity of this area. If I can have one pass, just setting out what we say the principles are in 2 minutes. So all we're concerned with here is the situation where a contract is entered into through agency. That's all we're concerned with. No one says anything else happened. Where an insurance policy is entered into through agency, if the putative principle is identified in the policy, there is no requirement to prove the intention of the agent. One derives the intention of all the parties, all of them, by looking at what the policy provides. If, by contrast, the putative principle is not identified in the policy, then it is necessary to prove the intention of the agent. It is necessary to prove that the agent intended to insure up to the extent contended for.
Does anything turn on what Mr. Justice Leggett, the distinction he draws between unidentified and undisclosed?
So, unidentified is a subcategory of undisclosed. Within undisclosed, and we are very much now into controversial and difficult areas. But undisclosed, there are two subcategories: unidentified and unidentifiable. Unidentified is where the agent could have identified them at the time the policy was incepted. Unidentifiable is where the agent could not have identified them at the time the policy was incepted. So it can be distinguished. It can be distinguished in this way. Conway is either identified or identifiable because you see it there on the face of the policy. If you don't accept that it's identified on the face of the policy, then as at the time the policy was incepted, the agent, the RFU, knew that it intended to insure Conway,
Okay.
so Conway was identifiable. Someone who is...
Okay.
It's still undisclosed,
Yes.
if not identified on the face of the policy. It's still undisclosed, but it's identifiable. Unidentifiable is someone that the RFU has not yet decided will undertake works at the time the policy was incepted. So if the RFU lets some works a year after the policy was incepted, then as at the time the policy was incepted, that party was unidentifiable. That party may still participate in the policy, but it participates in the policy only to the extent of an underlying contractual obligation. That's where the underlying contractual obligation bit comes in, and that's Haberdasher's ask, and that's the obiter, Mr. Justice Coleman's obiter in BP and Varna. There are three distinct categories of agency and three distinct sets of rules that apply to them. If I may, my lord, disregard unidentifiable at this stage, because on no one's viewed as unidentifiable arise on the facts of this case.
Right. So were Conway undisclosed or unidentified?
Both. So unidentified is one of the two subcategories of undisclosed. Undisclosed may be unidentified or unidentifiable. On Conway's primary case, it was identified in the policy. It being identified in the policy, the intention of the insurer, you derive solely from the policy. But Conway has to prove it authorised the agent.
What's the difference between unidentifiable and undisclosed?
So
I read it as meaning undisclosed meant the fact that there was a principle wasn't disclosed, whereas unidentified meant that although the existence of a principle was disclosed, the identity of that principle was not disclosed.
But the analysis is still the undisclosed principle analysis. Whether it's unidentified or unidentifiable, we're within undisclosed principle.
Yeah.
Because you haven't disclosed the identity of the principle.
So the primary case was unidentified. Sorry, primary case is identified.
And
So
yes,
intention irrelevant, only authority.
and
the secondary case,
the secondary case is identifiable as at the time
yeah,
the policy was incepted.
yeah,
In which case, Conway needs to prove both the intention of the RFU and that it authorised the RFU to enter into the policy.
yeah.
And what if you forgive me, I'll just refer to him as Mr. Justice Leggett and so on.
That's what he's
Key
saying.
distinction arises whether somebody's name is used or whether everybody knows that person arises.
So
So if Conway had been named, you say one set of circumstances apply. If Conway was identifiable because they were doing the work by that stage, you say a different set of circumstances arises.
so not exactly, my lord.
Yes, because you then say it would be intention.
So
Intention becomes relevant.
So that's not exactly where the line is, because identified does not mean the name Conway's in the policy. It means they are described with sufficient certainty.
All right.
So that's
I was using that in shorthand.
So that's described with sufficient certainty.
Yeah.
But if they are not described with sufficient certainty, if Conway was trying to get into this policy solely by the definition contractor, if it was trying to participate solely by the word contractor in the policy, then the question would arise, which contractor for which package does the RFU intend to insure?
So it means identified as the principal or a principal.
As a co-insured.
As a co-insured.
As a co-insured.
And you say that Mr. Justice Leggett's last sentence of 19 supports your proposition.
Yes, my lord. I mean, that is...
So those radically different things turn on that potentially quite small difference.
That's exactly right.
And the legal basis for that in construction insurance is what?
The legal...
In this case, why would it make any difference? Why should it make any difference?
So the reason it makes a difference is because of principles of agency.
No. In this case. Why should it make a difference in this case? Everybody knew that Conway were doing the work.
Well, my lord, if you are accepting Conway's primary case that it was identified as at the point the policy was incepted, if it was identified in the policy as at the point the policy was incepted, if you're accepting that case, then we don't need to worry about the law relating to intention at all. We can forget about all that.
Well, I understand that that's your submission.
Yeah.
I regard that as entirely counterintuitive, that you disregard the contracts that had been agreed between the respective parties. That's all irrelevant.
Well,
but I appreciate that's your submission, and you've supported it by reference to the references that you've made.
but my lord, with respect, it may seem commercially counterintuitive as an unusual thing. It may seem to be something that is unusual, and everyone agrees it's unusual. Mr. Morris's evidence was he'd never seen this situation before, but that doesn't affect, we say, the legal analysis, and the legal analysis is that on any day of the week, two parties can agree to enter into a policy of insurance.
Yeah, no, you've made that submission.
And the question of whether they agreed to enter into a policy, whether authority was given and intention was manifested, that is a question that exists, legally speaking, separately from the question of what the underlying contractual obligations were.
I understand that's your submission, yeah. Okay, so where do we go now? I'm conscious of the time.
So my intention, my lord, was to take the court through some of the judge's findings of fact and the emphasis that we place on those findings of fact, then to take the court to what we say is the law in relation to co-insurance, and then some more of the principles of agency. That was my intention, my lord. If that pleases the court.
You must take your own course. We've been asking you questions about the submissions you've been making. We haven't, I think, so far asked you to deviate from any course you had.
If we could go, please, let's go, please, to the judgment. So page 71 of the core bundle. So the basis of the judge's decision that Conway was not co-insured to the relevant extent with the RFU was that the underlying contract is determinative. That's what he found. The underlying contract is determinative of the extent of insurance. And he found that by reference to not only the principles of agency, which we've just reviewed, but also the principles of co-insurance. And we say that the judgments, the authorities that the judge relied upon don't say the things that he thinks they say. If we start, please, at paragraph 74 on page 71 of the core bundle.
(74),
74, please.
Yeah.
The judge is saying that the underlying contract is key to the extent and existence of cover. And he's saying that by reference to not only the insurance authorities, but not only the agency authorities that we've just discussed, some of which we've just discussed, but also by reference to Guard Marine. And as we shall see later in the judgment, he thinks that Guard Marine is a crucial part of the authorities that say the underlying contract circumscribes the scope of the insurance cover. Now, and indeed, when we get on to paragraphs 123 to 125, which are at page 81, he's construing the scope of the insurance. We see that at paragraph 123. By reference to whether the parties intended to create a fund of sole recourse. At paragraph 125, I'm satisfied that the agreement between the RFU and Conway did not provide that by taking out the policy, the RFU was intending to create a fund of sole recourse. And in doing that, my lord, in requiring the RFU, requiring Conway to demonstrate a contractual intention to create a fund of sole recourse in order to show that they were insured, what the judge is doing essentially is reversing the principles in cooperative insurance and Guard Marine that say the opposite, that cooperative insurance and Guard Marine are not in any way concerned with reading down the scope of insurance by reference to underlying contracts or underlying contractual obligations. They are concerned with the opposite of that. They're concerned with reading down, cutting down underlying contractual obligations by reference to the scope of insurance. That's what those two cases deal with. And if I may, I want to look first at cooperative insurance and the principles that we get from cooperative insurance, and then look at Guard Marine, and in particular the judgment of Lord Coulson, to see if they are saying what the judge thinks they are saying. So if we could please go to Authorities Bundle, page 111. So that's, if you're my lady and my lords have it, that's cooperative insurance. Now, I'll set out the facts briefly because they are important. CRS was the employer under a contract for the construction of an office building. Wimpey was the main contractor, and Hall was the electrical subcontractor. Taylor Young was the architect, and Hawley was the M&E consultant. Now, a fire occurred before practical completion and caused considerable damage to the works that were ongoing. CRS, Wimpey and Hall were all co-insured under a policy that covered fire damage. And for that reason, the employer didn't bother suing Wimpey or Hall. Taylor Young and Hawley were not co-insured under the same policy, so the employer sued them instead. They issued contribution notices against Wimpey and Hall, and the issue in that case was whether Wimpey and Hall were liable to the employer, or whether the effect of the insurance arrangements was to curtail liability. Now, if we go, please, to page 117 and paragraph 16, which should be sidelined in...
We don't have any sidelining.
Nothing
The
at all.
sidelining has just been electronic. There's been no paper sidelining at all. Well, that's not quite fair. There have been one or two black lines, but not here.
So those black lines will be from the original Lloyd's reports. Again, I'm sorry, my lord.
Okay.
So paragraph 16 should be sidelined, and we're within the speech of Lord Hope, and we see that it's common ground that CRS can't bring a subrogated claim against Wimpey or Hall, as they're co-insured in respect of the same risk under the same policy, and the policy has paid out. Now, that proposition, we say, has always been considered unarguable. In Surrey Heath, I'm not going to take your lordships back to Surrey Heath.
No, I think we need to do one case at a time.
But we say that proposition has always been considered unarguable.
That co-insured can't sue each other.
Can't bring subrogated claims against each other. There is a disagreement as to the situation that obtains when the insurance has not paid out. There's a situation as to whether there's a disagreement as to whether claims can be brought in that situation, and there's authority pointing in both directions. But what has been unarguable for the past 30 years is that where two parties are co-insured, they can't bring a subrogated claim against each other. And in this case, no one attempted to argue that. Similarly, in Surrey Heath, no one attempted to argue that. In Guard Marine, when we get to it, no one attempted to argue that. If we go on, please, to paragraph 20, bottom of the page, we see the main contractor's primary obligation, which was to carry out and complete the works. Over the page, please, at paragraph 22, we see that it was the main contractor, Wimpey, that was required to take out the joint names cover in that case. And if we turn on to page 119, we see the contractual arrangements as between the employer and the main contractor, which is the JCT regime whereby the insurance proceeds are paid out to the employer and the employer pays them out in turn to the contractor in exchange for carrying out the remedial works. Now that regime there was found as a matter of construction, as a matter of contractual construction, to preclude liability between those parties. But I want to look also at the position of Hall, because the position of Hall is important. If we go, please, to page 121, and look at paragraph 29, we see the contractual arrangements between the employer and Hall. Now, Hall had given the employer a collateral warranty, and it was pursuant to the collateral warranty that any liability from Hall to the employer would arise. There was no other contractual relationship between Hall and the employer. the collateral warranty was separate to the insurance arrangements. If one looked at the collateral warranty by itself, one would not see any provision for insurance in it, or any indication that Hall was not to be liable to cooperative in respect of the co-insurance. If one read the warranty, the only thing one would see is an intention for Hall to be liable to the insurer. You couldn't have a document that is more antithetical to the co-insurance defence than a collateral warranty, which is a document drawn up for the sole purpose of creating liability where liability would not otherwise arise. That's what this document was. Now, I just want to quickly go to Guard Marine just to show your lordships that Lord Coulson's understanding of what's going on here is the same as the understanding that I'm expressing to you.
Is that the only reference to this point in co-op? Just that observation in 29?
Yes.
Okay.
Yes, that's all I want to take you to. So if we go please to 255 in the authorities bundle. And at paragraph 142, by letter C, if your lordships would just read down from letter C. What Lord Coulson is saying here is that the commercial purpose of joint insurance is not only to provide a fund of sole recourse, but it's also to prevent claims. And at letter G, Lord Coulson is pointing out that Hall's obligation to use skill and care was in a separate contract from the contract between the employer and the main contractor that contained the insurance provisions. Now, if we go back, please, to page 121.
Yeah.
The reason I've taken you to this example, and this is something that I will develop when we look in more detail at cooperative retail and when we look at
well, we're looking at cooperative retail.
and
You
when
keep
we
saying you'll come back. You've got limited time, Mr. Garley.
yes, my lord. But
So where do you want us to go in co-op now?
so if we stay here, please. What the judge took from Guard Marine and from cooperative retail, the principle that he took from those cases was the idea that one reads down the insurance obligations by reference to the obligations in the underlying contract that give rise to liability. That's the principle he took, that the extent of insurance is, under the policy, is circumscribed by the obligations in the underlying contract that give rise to liability. And he analysed the position as being like that because of his interpretation of Co-op and Guard Marine, because of what he said about the difficulty of implying a term into an underlying contract that prevented the bringing of a claim in the face of express language to the contrary. The reason I highlight the Hall position is because in this case, in cooperative insurance, the House of Lords was prepared, A, to read the collateral warranty as not creating liability within the scope of the insurance, was prepared to do that as a matter of construction, and it was prepared, B, to imply a term into the collateral warranty that prohibited a claim between the employer and the subcontractor. And we say that a collateral warranty is the paradigm case of parties manifesting an intention that they should be able to sue each other. That's the only purpose of this document. And notwithstanding that, the fact that Hall and the employer were co-insured meant that the court was prepared to both read down the warranty to exclude liability and imply a term. And if we go on to page 126, please. We see paragraph 48 onwards, Lord Hope's conclusions on this issue, purely as a matter of construction, purely as a matter of contractual interpretation at this stage. He's not yet talking about an implied term. And he's saying that even in the case of Hall, the very fact that Hall and CRS are co-insured leads the court to read down the obligations.
You keep saying read down. Where does he say that?
Well, so...
It's not an expression I associate with Lord Hope. It's an expression I hate, because it can mean different things. So can you just show us the bit you're referring to?
So...
In paragraph 48.
Paragraph 48, C.
C.
The ordinary rules for the payment of compensation for negligence for breach of contract have been eliminated.
By the policy.
By the existence of co-insurance. Yes.
Yeah.
And that applies not only to...
They're not reading down anything. He's just saying there's a policy, therefore the two co-insured that don't have claims against each other. They've been eliminated.
So he's saying more than they don't have claims against each other.
Well, they've been eliminated.
He's saying the rules for the payment of compensation and negligence have been eliminated.
Yeah.
So what Lord Wilberforce would have described as secondary obligations in photo production and Securicor, the obligation to pay damages between these parties has been eliminated. Liability has been eliminated.
Yeah.
And that is distinct from the availability of a claim between those two parties, because you can still have underlying liability, but no claim is available. That's the point in this case. So the House of Lords holds that is true not only of the main contractor, but it's also true of Hall, the subcontractor.
Not because they were a co-insured.
Yes, but that's notwithstanding the fact that there was nothing in the collateral warranty.
You made that point. There's a collateral warranty. On one view of the collateral warranty, you'd think, well, therefore there must be a claim, and Lord Hope says no because they were co-insured. Is it any more difficult than that?
So,
and then they have an alternative way of doing it by reference to an implied term.
Exactly, my lord. And we'll look at that now at page 129, if we may. And that's paragraph 61. Mr. Blackburn here is accepting that this goes to the distinction I was just talking about, the distinction between liability and a claim. Mr. Blackburn accepts that there cannot be a claim between Hall and Wimpey and the employer, but he maintains that there could still be liability as between them. That's what they are arguing here. And over the page, Lord Hope, at paragraph 65, just looking at the conclusion, concludes that quite aside from the contractual arrangements, whatever those contractual arrangements may be, the very fact that two parties are co-insured means that one implies a term into their underlying contract that prevents any claim between them, and one does that to prevent commercial absurdity, the commercial absurdity being subrogated claims between them which the insurer would have to indemnify, which was Mr. Recorder Jackson's reasoning in Hopewell, which is approved here and is approved again.
Yeah.
So what we take from this and what we take from Gardnerine later is that where the judge says that the co-insurance cases indicate a problem implying a term preventing claims or implying a term excluding liability into an underlying contract, that's an illusory problem. The problem of implying a term contrary to an express, where there is an express term to the contrary, is an illusory problem, because an express term to the contrary on proper construction would be a term that says you can have a subrogated claim within the scope of insurance. That would be an express term to the contrary. A term preventing claims can be implied even into a collateral warrant. So that's all we say about National Oil Well, and we say that...
that's all you say about
that's all we say about cooperative insurance.
Yeah.
And we say that...
So do we now go to Gardnerine?
Yes, to Gardnerine, please. And if we go to bundle page 212, so in this case, OVM were the owners of a vessel. The vessel was chartered to OLH under BERCON 89 terms. OLH then time chartered the vessel to China National Chartering, or Sinochart. At paragraph 2 here, we see that the demised charter party and the two time charter parties contained a safe port warranty. At paragraph 5, we see that Gardnerine, the claimant, were the hull insurers. The underlying contract provided that they were to be co-insured. There was a total loss of the vessel. The hull insurer took assignments of all the rights of the two co-insured and brought a claim against Sinochart for breach of the safe port undertaking. So the first thing to note about this case is that it's not a claim between two co-insured. It's concerned with whether there can be a claim over an uninsured third party that has as its basis an underlying liability between two co-insured. If we could go please to page 241. we are here within the judgment of Lord Sumption. And at paragraph 99, we see again Lord Sumption saying at the beginning, it's well established and common ground between the present parties that where it's agreed that insurance shall inure to the benefit of parties to the contract, that they cannot claim against each other in respect of the insured loss. And again, we say that the contrary proposition.
And that mattered in that case because,
So,
given that you say this was a claim involving a third party and was not between co-insureds.
So it mattered because the distinction in this case was as between the situation where there is liability between the two co-insured, and so there can be a claim over. So A can say, I was liable to B, and I claim against C in respect of my liability to B. But if there is no liability between A and B, there can be no claim over against C.
That did matter.
So,
on the facts of Guard Marine,
so what mattered?
the position between the co-insured did matter.
What mattered on the facts of Guard Marine was the difference between liability and the availability of a claim. The reason we say it doesn't matter here in the present case.
No, we're just dealing with Guard Marine.
So,
anyway, there it is. There's a repetition. We've now seen the point 3 times, maybe 4, at paragraph 99. So, where do we go now?
So, where's the passage which the authority for the proposition that you just made about liability?
the
distinction between that you're making.
So we see it further down.
Remember, we haven't got sidelining. So
I'm sorry. So what should have been sidelined in this is the whole of this page and the subsequent page down to 101,
including 101.
Including 101. So at the beginning of paragraph 100,
yes,
the distinction that Lord Sumption is drawing here is as between the situation where co-insurance extinguishes liability, which is what is in dispute in Guard Marine, and which was what was in dispute in cooperative insurance, where it extinguishes liability, and the situation where it simply prevents a claim.
Just if I can hurry you along, it looks as though the last part of paragraph 100 at the top of page 242 is where you might want to focus.
Yeah.
That's where he draws the distinction.
Yeah. Yeah.
Again, he says, which is the correct analysis must depend on the particular terms of the particular contract.
Exactly. But the point that we are making is that in our case, in the present situation, the insurance has paid out. So on either analysis, on the analysis that payment out extinguishes liability, or on the analysis that the underlying contract removes liability, eliminates liability, on either of the two viable analysis, to the extent that Conway is co-insured, there cannot be a claim. To the extent that Conway is co-insured with the RFU, there cannot be a claim against Conway. Now, the judge interprets Guard Marine as saying that an intention to create a fund of sole recourse is a precondition for insurance. or the absence of such an intention circumscribes the scope of insurance. Nobody in Guard Marine is saying that the scope of insurance is circumscribed by obligations in an underlying contract or by intentions manifested in an underlying contract. Nobody's saying that at all. If we go on to page 254, please. We're within the leading speech on the insurance issue, which is Lord Coulson's speech, and this should be sidelined from paragraph 139 down to paragraph 142. And paragraph 139 is relied on by the respondents, was cited by the judge and relied on by the judge as authority for the proposition that the obligations in the underlying contract, that give rise to liability, circumscribe or dictate the extent of the insurance obligations. And we say that that is not only not the principle in Guard Marine, but it's the reverse of the principle in Guard Marine. What Guard Marine is saying, and what Co-op before it said, was that insurance obligations circumscribe the scope of liability in underlying contracts. The judge has taken this case to be saying the reverse. If we look at paragraph 139, please, when Lord Coulson says the critical question is whether the contractual scheme between the owner and the demised charterers precluded any claim by the former against the latter for the insured loss of the vessel, what Lord Coulson is doing is reading the insurance position into the liability obligations. He is limiting the liability obligations in the contract by reference to the insurance. He is not saying that one reads the scope of the insurance by reference to the liability obligations.
Well, just let's take it in stages. The owners and the demised charterer, were they co-insured?
Yes, they were co-insured.
So, but the position as between the two of them matters for the purposes of the claim down the line.
It matters for the purposes of the claim down the line because.
So he's saying the critical question is whether, as between the co-insured, did the contractual scheme preclude a claim by the former against the latter?
Yes.
And that's a matter of construction.
Yes. But what he's doing, the exercise that he's undertaking here, exactly like the exercise Lord Hope was undertaking, is reading the insurance obligations into the liability obligations. And
well, we looked at Lord Hope, and I'm not sure that's a fair summary of what Lord Hope was doing. Lord Hope was simply saying they're insured, that's that. The question in each case is whether the parties are to be taken to have intended to create an insurance fund which would be the sole avenue for making good the relevant loss or damage.
Now that's a question. The question there, the analysis there is the fact that they are co-insured, or the arrangements for co-insurance, is that to be interpreted as meaning that the parties do not intend for there to be liability? That's the direction of the exercise. Is the fact of co-insurance or arrangements for co-insurance to be interpreted as meaning the parties did not intend for liability to arise. The exercise does not operate in reverse as the judge thought it did. The exercise is not, do the liability obligations under the contract mean that the scope of the insurance is curtailed? Nobody says that. No one says that in Guard Marine, no one says that in cooperative insurance.
But in Guard Marine, Lord Toulson's talking about the contractual scheme.
Yes.
He's not talking about the policy, he's talking about the contractual scheme.
So that's exactly my point.
So it's a question of looking at the contractual scheme.
So
in this case, the letter of intent and the JCT contract.
No. So no. What he's talking about here.
So what's the contractual scheme in this case?
The judge here is not trying to determine the scope of the insurance. That's not what he's trying to do. There is no part of Guard Marine that is concerned with determining the scope of the insurance. The exercise...
No, that wasn't my question. On the face of the words used by Lord Toulson in paragraph 139, the contractual scheme, it's a question, as it is in each case, of construction. If applied to our case, on the face of it, that would look to be a reference to the letter of intent and the subsequent JCT contract.
But he's asking a different question to the question in our case. That's my point. The question that he is...
Okay, so hang on a minute. So 139, if applicable, goes to, in our case, the contract. But you say it's not applicable in our case because...
We say that there are stages of analysis. The first
no,
stage...
just why is 139 not applicable to our case?
Because Lord Toulson is not asking the question, is there insurance or what is the scope of the insurance? That is not the question that is being considered here. There is no dispute about the existence or scope of insurance in Guard Marine.
So he's asking this question because?
He's asking the next question down the line, which is, having ascertained the existence and scope of insurance, or ascertained the arrangements for insurance, what is the effect of that on the parties' liability to each other? That's the question that he's asking here. What is the effect of the insurance on the parties' liability to each other?
Isn't that precisely the question that arises in this case?
But you don't run all those questions together.
What is the effect of the insurance on the parties' liability to each other? So I'm bound to say, having spent some days pre-reading, I thought that was the question the court was being asked.
It's the ultimate question that the court has asked, my lord. But the question is taken in stages. One first ascertains the scope of the insurance, and then having ascertained the scope of the insurance, one determines what is the effect of the insurance on the parties' contractual arrangements. That's the exercise. One does not say what is the effect of the parties' contractual arrangements on the scope of the insurance. It's a crucial difference between the two exercises.
So you say first you assess the scope of the insurance, and then the second stage was what?
What is the effect of that insurance on the parties' contractual obligations to each other? They're the two stages. And if you run those stages together, as the judge did, we say you get the wrong result. Because as we see from the very next paragraph here, what Lord Coulson is discussing in the very next paragraph is the Hall situation. And again, he discusses the facts of Hall, and at E, he says, this raised the question of whether Hall was liable to the owners in respect of the fire damage as alleged. If we go down to F.
Well, that's just summarising what you've already shown us in Hall.
So, but the fact that what is under consideration here in Hall, the fact that what is under consideration here is Hall, is relevant to us understanding the exercise that Lord Coulson is undertaking. In the case of Hall, as
well, he says all questions of questions of construction, it depends on the provisions of the particular contract. See, for example, cooperative.
In the case of Hall, there was nothing in the collateral warranty relating to insurance.
Yeah, you've made those submissions.
And notwithstanding that,
Hall actually, cooperative retail insurance, with great respect to Lord Coulson, wasn't really a question of construction. They didn't look at the detailed provisions. They just said, well, they're co-insured.
Yeah. But
which is the case that you edge towards and sometimes shy away from.
Well,
but I mean that's the nice, simple, one sentence point. But I quite appreciate that your submissions don't hang on that, and I fully understand that.
But they said it in cooperative retail, my lord. They said it on both bases. In the section where Lord Hope is considering whether liability has been eliminated as a matter of reading the contract, he says that applies to Hall as well. In the section dealing with the implied term, where he's prepared to apply a term into Hall's contract, he also concludes that liability is eliminated in the case of Hall on that basis, both on the interpretation basis and the implied term basis.
All right, so is there anything else in Guard Marine?
Nothing else in Guard Marine.
For my part, it would be quite useful just to pinpoint, just for a second, where you say the judge went wrong in interpreting these provisions.
If I may?
I mean, I don't want to take you out of your way, but just so I'm doing.
Absolutely.
Just reference to the paragraph numbers, we didn't go through it all.
Okay, so
where did the judge go wrong in interpreting it? If it's your case that he did, which I think it is.
So, paragraph, perhaps easiest to go to the judgment.
That's what I mean, yes.
So, page 71 of the core bundle, please.
Yeah.
So, if we look at paragraph 74, and we look halfway down,
right. So that's a quotation
from Guard Marine,
which we've looked at.
So what the judge is saying here is it's the terms of the underlying contract that provide the key to the existence and extent of the insurance cover. Thus, in Guard Marine, paragraph 139, Lord Coulson identified the critical question as being the effect of the contractual scheme. What Lord Coulson is saying at paragraph 139 of Guard Marine is not that the underlying contract is key to the existence and extent of the insurance cover. He's not saying that at all. He's not discussing the existence and extent of the insurance cover. And the fact that he's not saying the underlying contract is key to the existence and extent of the insurance cover is we say, clear from the fact that he goes on to discuss Hall in the next section as an example of a weaker situation than the situation in Garde Marine. And Hall is a situation where there was no insurance obligation in the collateral warranty between the employer and the subcontractor. If we go on, please, to
Well, don't you have to read 74 as a whole?
Pardon?
I'm just looking at the first part of 74. What is important is the authorities are clear that in order to determine whether the insurance policy, insurance cover, applies to the contractor or subcontractor, it is necessary to look at the terms of the contract.
So the exercise that the judge is undertaking is he is looking at the liability obligations in the contract, the liability obligations in the underlying contract, both the letter of intent and the building contract, and trying to determine whether those liability obligations are compatible with the extent of insurance contended for by Conway. And we say two things about that exercise. We say that isn't the right exercise because even in a case like Howe, where the liability of the whole purpose of the document is to create liability, the whole purpose of the contract is to create liability. Even in a case like that, the underlying contract doesn't curtail the obligations. And the other issue he identifies as problematic, and I'll go to it now, the implication of a term, it's an illusory difficulty because the court is prepared to imply a term eliminating liability into collateral warranties that again, have as their purpose the creation of liability.
Well, you've made that submission.
If we go on to 76, please.
Well, I'm just conscious of the time. You haven't addressed the grounds of appeal, and you'll need to do that. But I think, to be fair, aren't we in a position where we could only really allow you another hour because Mr. Reid will need to respond, and although I quite understand that Mr. Wheatle will also need to respond, I'm assuming that the bulk of the heavy lifting will be done by Mr. Reid. And so you've had half a day, so if you have another hour, then Mr. Reid will have an hour this afternoon and tomorrow morning, thus leaving the rest of the time for Mr. Reid and any reply. Sorry, Mr. Wheater and any reply. So I think if over the short adjournment you can, I mean, obviously you've covered a lot of the ground, but if you can cut your cloth so as to do that, that would be helpful. Shall we pause there and come back at 2?